What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you are all having a great day so far. Happy Sunday. Happy Sunday. Hopefully you guys had a great weekend. Yay. I got nothing else. Anyways, you want to watch some court? I want to watch some court. Let's watch some court. I've got two cases tonight. I've got one with Judge Elmore and one with Judge. Don't even remember the second case. Yeah. Oh, Judge Middleton. Man, it's a hard one to forget. Don't. Yeah. Anyways, Judge Elmore, Judge Middleton. Judge Elmore has a guy who, yeah. I don't really want to spoil it too much. Hopefully you haven't seen it because it's a really good one. And then the Judge Middleton one is it's a debt collection case. I know it's been everywhere. Hey, it's Sunday. I lost all of my court content, 3 days ago, so I'm kind of starting over. So we're gonna have some fun anyways. So let's just watch it and enjoy. Real quick, we've got some milestones coming in. Thank you guys. Leah for 7 months. Thank you so much, Leah. You are awesome. And thank you so much for your kind words in Discord uh, that you said the other day. I do appreciate it. Hopefully, the links I sent you will help you with your slow days at work. If you need anything else, just let me know. But yeah, hopefully that was what you were asking for. But yeah, anyways, Leah, thank you so much for your 7 months. Larry, good to see you, my friend. Good to see you. Keep on trucking. Yes, keep on trucking. Thank you so much for the 10 months. And Sharky for the 17 months. Thank you so much, Sharky. I do appreciate it. All right. Milestones out of the way. You guys are awesome. Yeah, let's just get into it. You know what? I do have to say one thing. I've been having some crazy internet issues today. My internet has gone down out of nowhere for an extended period of time, multiple times today. And every time I've looked, I've gone to my ISP, like, is there an outage? Is this on me? Like, what's going on? I get this auto response that just says, there's an outage in your area. Don't bother calling. The technicians can't help you. We're aware of the outage. Like, how does that make sense? When is that the response? But anyways, it's happened at least three times today. I've lost internet for about 30-minute periods. If that happens tonight and the stream just ends, we'll finish the stream. Not tomorrow night. Tomorrow night's Members Monday. We'll finish it on Tuesday night. But yeah, we're gonna get through these cases. Hopefully we make it through tonight. Okay, that's all I gotta say. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Prosecutor.
Thank you, Your Honor. Good morning. David Denhoughton on behalf of the people.
Robert Hackett appearing on behalf of Mr. Woodworth, apparently in both cases today.
Apparently. All right. Well, one of them is actually just being nollied, if I understand correctly. So
That is correct, Judge.
that one, all I've got to do is put a signature on a page, so we're good to go there. All right, let me pull up the right file. And there it is. All right. Are you Mr. Woodward?
Yes, I am.
All right. Thank you very much. Also here before the court this morning is Miss Laura Odell. She is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. Let me take a quick look. I don't think I had any corrections, if I recall.
There are a couple of additions that we just learned about this morning, Judge.
Yeah, I'll turn it over to you all. 1 second, though. On CFJ 284, page 8, looking at the defendant's adult history, that first entry for
Judge Elmore is a judge in Michigan, and he wears multiple hats. He's a district court judge and a circuit court judge. he is in one of those small districts or small jurisdictions that covers a bunch of different places. Yeah. But he's in Michigan. I cover him not a ton, but I mean I watch him almost every day. So yeah, that's Judge Elmore.
Status at the time of the offense. Looks like the offense was 12/23/94. But he had a couple juvenile cases that were charged, had alleged events occurring back in December and even November. Was he on bond at all at that time or
Your Honor,
probation?
I apologize for interrupting you. It actually looks like that should be included in the juvenile section.
Okay, and that's that was, so either he would have been a juvenile at the time or he would have been.
Muse, I did not realize that until you said that. Yeah. Apparently the survey is available in Mandarin, not the stream.
On some kind of bond that he had absconded, yada. And the reason why I thought maybe it was an absconding was because the discharge date is 98, but again, the disposition is 94 still. So yeah, we need to move that down into the juvenile section.
Thank you.
Yep, no problem. All right, let's take a look here and I'll keep on going.
Cheshire Cat, my friend, thank you so much for the super chat. I appreciate it. It was me. He was talking about me as well, by the way. Yeah, no, it's always your fault. All the internet problems is always your fault. And also, Cheshire, thank you so much. I know you like to drop super chats at the very end of streams, and I don't always thank you, but I do see them, and I appreciate it. And I like your jokes. I like those kind of jokes. They're funny. And Muse coming in at 15 months. Thank you so much, Muse. I appreciate it. Thank you.
All right, so that concludes what I had to address. Let's turn it over to the prosecutor. Mr. Denham?
Thank you, Your Honor. On CFJ 145, page 2, with respect to the jail credit, it's my understanding that Mr. Woodworth was in inpatient treatment beginning on February 10th, 2026. So the credit should be modified from 57 days to 27 days, I believe, Your Honor.
Yeah, thank you. And I thought he was in treatment, but when I saw that, I couldn't remember if I had revoked it or something. All right, well, thank you very much. Mr. Hackett, I assume you don't object?
I do not, Judge.
Any other changes, corrections, or objections on behalf of the people?
No, Your Honor.
All right, Mr. Hackett, the ball now is back in your court. Any corrections or objections?
No objections, Judge. Just a couple of additions on page 18 of the CFJ 284 under the substance abuse treatment section. You did order him into inpatient treatment at DOT. He went in on February 10th and he successfully completed that program on March 10th of this year. So I think that the end date should be put in there, and obviously he completed it.
All right. Yeah, that's perfect. Thank you very much. We'll go ahead and make that change. Any other corrections, Mr. Hackett?
No, Judge.
All right. Thank you very much. We'll begin with allocution from the people. Mr. Denham.
Thank you. Your Honor, the people do support the recommendation. In some respects, the one, I guess, area that the people would differ somewhat with the probation department is the recommendation is for there not to be any community supervision, for there to be a straight jail sentence. We understand the recommendation is based upon the defendant's prior history on bond and prior substance abuse convictions. However, there was a significant period of time where, according to the PSI as well as defense, where the defendant was free from illegal substances. He has just now gone through inpatient treatment successfully. And we believe that a period of probation with testing would be appropriate to ensure that Mr. Woodworth continues on his path towards substance abuse history, freedom from substance abuses, from substance, all illegal substances. So that's one area that we would differ, but in other respects, we would support the recommendation.
All right, thank you. Mr. Hackett?
Thank you, Your Honor. There was a jail cap in this case, Judge. Guidelines are 10 to 23 months. I'm going to ask, Judge, that you go ahead and either give him credit for time served at this point, or go ahead and suspend any additional jail so that he may stay out and continue to work. I know that he has obligated himself or his company to a number of projects in 2026 that he's already taken money for. I don't want him to see him get in any legal issues with regard to that. Not suggesting he would. He's done 30 and 30 for AA classes, NA classes. He does have the sign-in sheets there he can provide you, Judge. He will continue to do that. And I also know that he has outpatient services intake on Monday. That he'll begin the outpatient services, and he will follow through on all of that, Judge. He's doing very well. He's probably better than I've seen him. And I've known Mr. Woodward for probably 20 years now. Thank you.
All right. Thank you. All right, Mr. Woodward, you have the right to make a statement if you choose to do so before the court issues a sentence. Is there anything you wish to say at this time, sir?
Yes, Your Honor.
There you go. Thank you.
Your Honor, I would ask this court to consider a downward departure from my guidelines to the 57 days I have served, along with imposing a substantial fine, which I am prepared to pay to the court in full today. I believe this departure can be warranted based on the fact that I take full responsibility for my possession of dangerous drugs, along with my completion of inpatient residential rehab in the 30 meetings and 30 days I voluntarily did in addition to the residential treatment. I stand before you today with 2 months of sobriety under my belt and no desire to return to active use. I'm a small business owner with lots of ties and obligations to this community. Being in the event rental business, many of my clients often book events with paid deposits months and sometimes years in advance. I am a hard worker. I own my home. I pay my taxes, and I want to be an asset to the community by being able to fulfill my current obligations. That said, if this court does not see fit to sentence me to time served, I would humbly request any additional time ordered be suspended, therefore allowing me to keep my home and my business intact.
All right. Thank you. All right, folks.
All right. Nicely said as far as the defendant's speech. That was good. You know, he owns his own business, pays for all of his taxes. Good for you. Yeah. Big problem with this. It's what he's charged with. I feel like the prosecutor and the defense attorney kind of both, they're on the same page. Like, yeah, we're hoping to get a lesser sentence out of this. But when Judge Elmore sees what let's just say this. The one thing Judge Elmore does not waver on are people that allegedly deal drugs in his jurisdiction. Yeah. We've seen it multiple times. Yeah, take a seat, dude. You're about to get a speech.
As I often say, it's not until this moment in a criminal case in which the court is allowed or is charged with exercise. Oh, you may go into a seat, sir. Exercising its discretion. And so I'm going to go over several things and the law, and for particularly the appellate courts require trial courts to explain as much as possible about their judgment.
I am so sorry. I meant to thank you, Legal Fiction, for your gifted memberships during that pause. That's why I paused it. And then I got so excited that I just played. Legal Fiction, thank you so much for the 10 gifted memberships. I appreciate it. Welcome to the 10 new members. Legal Fiction, you are awesome. Thank you.
Justification for the sentencing. Well, and some of this I just have to know, because if I don't, somebody will pick at it. Well, we begin by looking at CFJ 145, page 1, and we see an extensive history of alcohol and marijuana beginning when the defendant was a juvenile. And then as he grew, it added to, for a short period of time, I don't know how much, but at least a little bit for a 2-year period, there was cocaine use. There's been methamphetamine use for the last 5 or so, and there were opiates for about a 10-year period of time back in his young adult time. So he struggled with substance use disorder a great deal. And we see that, of course, referenced in the history back in CFJ 284, where it talks about the defendant's attendance at treatment. And again, he's had multiple attempts at treatment, and some have been successful. And I greatly appreciate and acknowledge that, because that is a positive here. Sentencing is not always about penalty, but is also about rehabilitation. And so here he had completed some other programs, and most recently completed the program that Mr. Hackett discussed. And I think that's a great opportunity for Mr. Woodward to have had, and I hope that it sticks with him. Now, when we talk about the defendant's prior criminal history, it's quite extensive, both as a juvenile and as an adult. And within that history, and of course, by the way, I want to make sure it's stated on the record, the court does not consider any case that was dismissed. So there were some that were dismissed as a juvenile. I'll note that a few may have been dismissed in exchange for a plea in the other case, but I don't have any facts, so therefore I can't make a finding by the preponderance of the evidence to consider those. Therefore, the court does not consider any file for which the defendant received a dismissal, whether it was dismissed as an agreement or is dismissed just outright. The defendant has had some issues, both as an adult and as a juvenile, with crimes of dishonesty. We see a break-in and entering in 1994. And while on probation, he picked up multiple cases. Again, a couple of those were dismissed. But one of them in 1994 involved receiving and concealing stolen property, as well as use of controlled substances, specifically marijuana. And while that case was pending, actually about a week later, he picked up another case, and that was a unlawful drive in a way of a motor vehicle. And then, and as I mentioned earlier, there were multiple ones all but bunched up together. There was another one also within that month period of time that involved a break-in and entering, and then another one that involved
Heather. Hi, Heather. 29 months. The OG member. Hi, Heather. Love you. Phil, thank you so much for the 10 gifted memberships. Welcome to the 10 new members. Thank you so much, Phil. Appreciate it. Sorry, Heather gets an automatic pause when I see her name pop up. All right, let's keep going.
A break-in and entering, uttering and publishing, and unlawful drive in a way. And then in 95, which was only about a month or two later, he picked up another case involving escaping from lawful custody while he was awaiting trial. So in there were some significant series of cases. Well, then he picked up that other one in 94 that also had to deal with controlled substances. So until he became an adult, there was quite a history. And that has continued even as an adult. The defendant began in 96 with some criminal charges and convictions. And right away, while he was on probation or juvenile supervision, he committed yet another property crime and was placed on and given a chance of probation, and he was unsuccessful with that probation. In fact, he was on bond for that file when he picked up the next case, which was, sure enough, a property crime. And then there was another case at the same time, also on violating bond, and yet that was another property crime. And what's important here to note is that the defendant did not, he was given a period of probation and a boot camp. He didn't complete either one successfully, and then was sent to prison. Well, while he was on parole after being released, he was paroled on October 28th of 1999, and he made it about 9 months before he picked up a violation and committed another offense. While it's not significant, maybe not overly significant, it wasn't operating while intoxicated. So again, we see issues of controlled substances. Well, while he was on parole and maybe, I would assume, bond for that last one, he picked up yet another one, and that was 13 days later, driving license suspended. Not a big case, but this court takes a look at those and sees that it's kind of a crime of dishonesty as a person is doing what they want to do, hoping they don't get away with it, but sure enough, they get caught. Then about a year later, he picked up a disturbance of peace down in Grand Rapids. After he was discharged from that case and that was resolved, he made it 3 weeks in 2002 before picking up another property case. And looks like he had some parole. Yeah, he got a prison term. Then when he got paroled on March 15th of 2005, he made it 4 months before picking up another offense, and that was a drinking and driving. He received 12 months of probation and 85 days of jail. And he tested positive within a short period. Well, I'll take it back. I'll say he made it 4 months, 5 months before testing positive for cocaine, and his probation was discharged unsuccessfully. Well, after that case was discharged, he made it 2 months before picking up some other offenses. Those were in this court, and they involved assault with intent. To commit. Well, after all that, and he was released from parole.
Hey, my internet just paused for a second. Am I back? I'm hoping this is fast. It keeps blipping on me. All right. All right. Can you guys hear me? I'll rewind. I'm gonna rewind it about a minute. So I feel like it's been about a minute. I don't know what you guys could hear and what you guys couldn't, but I'm gonna rewind it about a minute. All right, you guys can hear me. All right, I'm gonna try to pause as little as possible to try to get through this. Like I said, I've been having massive internet issues today. Like it's been bad. It's not my normal issues. It's not me. All right, let's go. You guys are awesome. Thank you so much for your patience.
He was paroled and had no violations. Well, but I should say, he actually had 2 cases going on at the same time, both involving criminal sexual conduct, and both resulted in, looks like, a prison sentence and he had no violations during parole, which was for picked up some weapons charges, being a felon in possession of weapons, which is concerning. When we had the CST cases and then we have weapons, there's no charge apparently for having used the weapons, but there's an element of dishonesty here. Well, with that, he even apparently had some violations on his probation. So now we jump ahead to about T2, and sure enough, we end up, well, there are charges for violence, but it was resulted with a disorderly person for jostling. Now that would have been in front of me back in 2022. Looks like he entered a plea for domestic violence and was given a kilo brew agreement where it was reduced. So that was successful. And he made it about 1.5 years before picking up a minor offense, driving license suspended, but that's concerning to the court is whether or not he's going to comply with the orders of courts, not to violate laws, not to drive, rules of the state, don't drive unless we tell you can. And then after that, which was resolved on January 6th of 2025, he made it 3 months before he then picked up another driver's license suspended. So that's telling me that he's not going to learn his lesson there. After that case was resolved on April 28th of 2025, he made it just less than 2 months before he picked up the pending offense. Now, In the meantime, while the charge offense date was June 17th, and he hadn't been arrested until October, in the middle, there was this other charge. And that's the other case that we're here to dismiss today. So
Is it that bad? Is it that bad? I mean, I don't know what I can do about that on your end though. It's crystal clear. It's in 1080 on my side, but if it's that bad, then yeah, I might just cancel the internet. I mean, cancel the internet, cancel the stream, because this is bad. This sucks. This sucks. I should have just canceled the stream tonight, guys. I'm sorry.
got a series of repetitive crimes, acts of violence, acts of dishonesty, acts of failing to comply with probation, comply with bond, comply with parole. And of course, I need to make a note here in this case that the defendant had violated his bond multiple times, and that information is contained in this report on CFJ 284, page 3. In fact, there is a lab test confirming that he tested positive for methamphetamine, and it was a relatively significant amount, 1,780 nanograms per milliliter, and also some failures to test in the middle there. So the court clearly, when it elected to allow him to go to the treatments, because I'm quite concerned, and whenever I give a sentence, the sentence is supposed to be a balance between the person, the offense, and the objectives of sentencing. Now, because the court is allowed to consider and make findings based upon a preponderance of the evidence, and there's been no objection to the contents inside the PSI, this case doesn't need to go any further, at least my judgment. CFJ 284, page 3, paragraphs 1 and 2. CI met with Woodworth and money was exchanged for methamphetamine in the garage. Woodworth placed the methamphetamine into a partially consumed bottle of water to conceal it in case of police contact. The CI then followed Woodworth into the main area of the house and spoke with him briefly before leaving the residence with methamphetamine dissolved in the water bottle. After exchange, the CI drove to a predetermined location. Now the next paragraph. The liquid inside the bottle weighed 184 grams, including packaging. So, Mr. Woodworth is a drug dealer. Now, he hasn't been convicted of delivering drugs. He received a significant benefit in this case. A delivery of methamphetamine would have been a Class B offense, not a Class D. And as a fourth habitual enhancement, I guarantee you most likely would have scored undoubtedly a prison sentence with a maximum of life. Or as a second or subsequent, the guidelines and the minimum could have been doubled, and the maximum could have been doubled as well. So again, this court understands that there has been a Killebrew agreement, and this is why I do not do Cobb's agreements. This is specifically the example why, because I don't know all this information. I don't get it presented to me when I'm taking a sentencing. And this is why I often speak whenever I talk to other judges. I would stop doing Cobb's agreements because of this example. So there is actually, I'm going to let, because it's a Killebrew agreement, of course, the defendant's going to have the right to withdraw his sentence, and but the court still has to give a sentence. The court assesses a $68 state minimum fee, a $130 crime victims' right fund fee, a $300 court cost as this case is been processed throughout the system. The court's going to assess a $5,000 fine. There is no attorney fee because counsel is retained. There's no supervision fees because I'm not going to place the defendant on a period of probation, and I am not going to follow the pretrial agreement for a jail cap. This is a drug deal.
Boom! Did you see how the defense attorney his neck just snapped? Oh, I told you. If you're dealing drugs, do not do it in Judge Elmore's jurisdiction. No, sir.
No, I have no idea how anybody thought that I would comply with this, but I still have to give a sentence, and the defendant will be allowed pursuant to the pretrial agreement to withdraw his plea. The court sentences the defendant to a prison term of 23 to 120 months and awards the defendant the 27 days of credit. The facts of this case demonstrate that the defendant is a drug dealer. Now, also, I'll even note in here, one of the statements was he recognized that, hold on, I'm going to find it because I want to get it, on CFJ 284, page 1. It is hoped he realizes that he is less likely to be respected and to be seen as a professional if he is known to be engaging in the sales and use of dangerous controlled substances. Yeah. Therefore, that's the sentence of the court. Mr. Hackett, do you need to speak with your client and talk to him about his desire to withdraw his plea? Or do you,
Yes,
or do you already know? All right, no problem. What I'm going to do, Mr. Woodworth, is you are ordered not to leave the building, but you may step out in the hallway and you may use one of the rooms out there to call into Mr. Hackett. Do you have his cell phone?
Yes, sir.
Mr. Hackett, do you have your cell phone with you?
I do, Judge. I'm actually on it. Can he go ahead and zoom in to your number, Judge?
Yes, I will write that down for him. Linda, you will take it out to him.
Thank you, Judge.
No problem. Thank you very much. All right, Linda. Thank you. Bond is hereby revoked, and we'll continue in a few minutes. Thank you.
Oh, and then the final punch. Bond is revoked too. Yeah. So for those of you that didn't follow that, there's a lot of Judge Elmore spoke a ton of the guy's criminal history. The prosecutor spoke for, I don't know, a minute. The defense attorney spoke for a minute. The defendant spoke for about a minute with his allocution, and then the Judge Elmore just went ham on the entire criminal record, and it said, nope, not in my court. I am not taking this deal. No, we're not doing that. I don't do Cobb's agreements. This is why. And yeah, and then because Judge Elmore is not following the agreement, the plea agreement, the defendant has the right to withdraw his plea. So that's why he said, do you want to go talk to him? And he said, yes. He's like, oh yeah, by the way, your bonds are revoked as well. So yeah, you're going to jail today. Judge Elmore. We don't see a lot of judges do this where they just like, I'm gonna put my foot down right here. No. This is the line. You will not cross this line. Anyways, they spoke. Let's go. Let's finish this one up.
All right. We're going to take up back the file of People versus Michael Woodward. Again, the two files are.
You know what? I will explain it the best I can, but Alex, you actually probably know better than I do. It's when the prosecutor and the defense, they come to an agreement, and a Cobb's agreement is, hey, this is our agreement, and they expect the judge to follow it. That, to the best of my knowledge, that's what it is. And they put it under it's under the title Cobb's agreement because some judges will allow it, some judges won't. Judge Elmore isn't one of those judges. So, the judge has the ultimate say on whether or not he goes with a plea deal. If the prosecution decides to drop 3 out of 4 charges and keep one, but the Cobb's agreement, I think, is on the sentencing. I think that's the important part of it. It's on the sentencing of the case. So that's what they were hoping that the judge followed the sentencing. He said nope. Yeah, I think. Yeah. Anyways, that's the best I can explain it.
25-3630 and 3650FH. The court recognizes before the court all the same parties and counsel. And Mr. Hackett, you're still able to see and hear me? All right, thank you very much. Mr. Hackett, were you able to speak with your counsel, or did you have any problems with the technology?
So he has multiple bond violations. In the, I don't know, 20 minutes Judge Elmore was talking about him. He has a few bond violations. Also, he just said that he's going to put him away for, what did he say? 30 months? Whatever the number was. So he just let him know what he's planning on doing. So like, hey, you're going to jail for 2.5 years. Do you want to withdraw your plea? He's gonna be like, yeah, I want to withdraw my plea. Let's take this to trial then. And then he's gonna walk out of the court. That adds a potential flee to the bond. So he may have just said that to, in the time. I don't know, but he explains it here shortly. I guess I should have said that. I could have clarified that a little bit. He does explain it here shortly.
I was able to speak to Mr. Woodward, Judge. I spoke to him on the phone.
Hold on. Let me have Linda that 1 sec. Oh, they're gone.
There we
You
go.
were able to speak. You were able to speak with them.
I was able to speak to him, Judge. And, based upon the Killebrew agreement to a jail cap, he would like to withdraw his plea. And he would request that bond be reinstated so that he can continue to defend his case. His cases.
All right, thank you very much. The court by law and pursuant to the pretrial agreement under Killebrew, the court therefore grants the request to withdraw the conviction and the sentence and the case. And I assume that the other case, I'm not going to sign a nollie process this time. Is that correct, Mr. Denham, or do you still want me to sign that?
No, Your Honor, that we would not be entering at the time.
All right. Thank you very much. Now, earlier I said bond was revoked. Largely that was because I didn't want the defendant to leave the building. And I know we had a detective that was available to help monitor that. So now the question is requested by Mr. Hackett on Mr. Woodward's behalf, is to reinstate bond. Mr. Denham, your position, sir?
Your Honor, it probably is already a condition, but we would ask that the testing be a requirement, Your Honor.
Sure, no problem. Thank you. All right. Well, the court generally sees a concern in these situations because now I've made a statement as to where what the court is focusing on for sentence and what the court is likely to do. What's in a different situation here is the defendant and counsel now again have heard what the court finds to be important about the case. Now again, that is all based upon what was in the PSI. The PSI no longer really exists to me at this time. So it's no longer a factual consideration and for sentencing, but it's relevant to this court for considering potentially what to do on bond. As I mentioned, we've had a variety of bond violations, probation violations, parole violations, repetitive offenses over and over again. And the court now knows more about the case, and the court underneath Court Rule 6.106 recognizes that the likelihood of conviction is somewhat high based upon at least the facts as I understand them now. It involves a system used.
No, the defendant's actually at the table by himself. He's wearing a really nice suit. The defense attorney is on Zoom. The prosecutor is on the table to the left. And then clearly the judge is the top left.
By detectives that involve informants, searches, generally audio. I don't know if they had audio here, but things like that. And the defendant faces the potential of up to life. Now, he did do a treatment program. He hasn't fled, but he did the treatment program after getting the benefit of the pretrial agreement. So, Mr. Hackett, what does your client do again? Help me from looking back into the report. What does he do for work?
He is the owner of basically a tent company. He goes ahead and contracts with private parties for weddings and graduations and outdoor events that would need some type of structure in order, I assume, to be safe from the elements. So
yeah. All right. So
yeah, and I understand that, but here's the problem. One of his charges is drug dealing, allegedly. And he works for party events, putting up tents. How? Sorry, my mind wanders sometimes. Maybe I watch just too many crime shows. But how is that not the perfect cover for someone selling you drugs? Hey, I'll put up this tent for you free of charge. How about some party favors on the side? Sorry, that's my brain. Not saying that's what happens, but yeah.
I understand what that is. All right. Well, thank you. All right. Well, the defendant does have a record of appearance. But he had a variety of bond violations before, and that's quite concerning to the court. And I only modified the bond, right, to allow him to go to the treatment program. Is that right, Mr. or Miss Odell? Is that what you recall?
That's my recollection, yes.
All right. Well, now that I understand the nature of the offense a lot better, the evidence behind the file, the defendant's prior criminal history, and the performances I discussed earlier, the court is going to deny the modification of bond, revoke bond, and remand him into the custody of the Missaukee County Jail. This case will now be set back on the court's trial docket very quickly for a next pretrial conference and a new trial date. Thank you. We're adjourned.
Thank you, Judge.
Thank you.
Yeah. So he came into court thinking he was going to walk out of there with, maybe some probation, maybe some time hanging over his head. Can't think of the word. What they do when they sentence you for we're going to sentence you for suspension. We're going to sentence you for 2 years. We're going to suspend it. That's what he was thinking. The defense attorney, the prosecutor, they already kind of worked out a deal. All the judge had to do is agree with it. Yeah, it didn't happen. And now he's going to jail. His bail was revoked. His bond was revoked. Yeah, that is not the way that he thought his day was going to go. Anyways, that one was fun. We're gonna move up. We're gonna move to the next one. I, I before we go to the next one, I want to give a giant shout out to Lucy, who she sent me a video I used yesterday, and I believe she sent me that one too. If not, that might have been Twitchy that sent me that one. I don't know. It was either Twitchy or Lucy, but I know Lucy sent me one from yesterday, and I forgot to shout her out. So Lucy, thank you so much. Also Twitchy, you're awesome. All right, we're gonna move on to the next one. Judge Middleton's courtroom. We have a guy that got his car repossessed, or his truck, a $50,000 truck repossessed. Yeah, you may have seen this one. It's fun. Let's go.
Next case, the defendants were here early. This is file 251578GC. It's entitled Omni Community Credit Union versus Chelsea Lafferty and Kevin Wilson. Miss Lafferty and Mr. Wilson are here this morning from their mobile world headquarters, and Lena Escamilla is here on behalf of Omni Community Credit Union. Miss Escamilla, I don't know if you know this, but Omni Credit Union got seriously damaged by the tornado last Friday. So the Three Rivers Omni is closed because of the tornado damage. Anyway, this is a claim of substantial size for district court standing.
Speaking about that tornado, I reached out to Debbie Davis just to make sure she was okay. Her family and her friends are all good. She did say that the community was heavily damaged, but they're all good. So yeah, I just wanted to drop that in there. Yeah, I don't really know where I was going with that. I just felt like sharing.
Standards $19,474.44. This matter was set for a while ago, but Ms. Escamilla was ill, and so we reset the matter for this morning. This is set for a motion for summary disposition. Ms. Lafferty and Mr. Wilson, you probably don't know what that means, but the plaintiff did file the motion, and they filed a brief in support of it. Essentially, what it means is that there's no dispute. A motion for summary disposition, as it was filed here, the plaintiff alleges that there is no material issue of fact that the debt is due and owing, and you haven't stated a valid defense. Now, they filed this claim that was served on you, and you filed a very brief statement, which we accepted as an answer. Response.
I got directly hit with a tornado. It was about 2 years ago. No, it was before I started my channel. It was a few months before I started my channel. I literally it went right over where I lived and completely demolished the area. We didn't have power for over 2 weeks. I think it was 17 days we didn't have power. It was a mess. And it was right when I was starting a job too. And it was, not something you want to tell someone who you just went through the interview process, just got the job. You're supposed to start on this day, and the day before you get directly hit with a tornado. I'm like, yeah, can we push this back a week? I have to take care of things here. Luckily they did. Like, oh, okay. Yeah. But yeah, tornadoes aren't fun. They cause a lot of damage.
We never purchased a truck from Royal RV. We test drove a truck from there, but it turned out to be a flood truck. So is it your contention that you never signed a loan with Omni Credit Union? There are certainly a lot of documentation. Now, you did object to the adjournment, and you also asked that the matter be dismissed. But Ms. Escamilla has a long history with this court of credibility, and she was sick, like flu sick. And so the matter was adjourned, and there's no reason to object. It just is what it was. So Ms. Escamilla, their contention somehow is that they didn't purchase a vehicle from Royal RV. You have filed a loan agreement with Omni Credit Union. What can you tell us about this?
Yes, Your Honor. So they did file the loan agreement, and my understanding is they also have had another loan with Omni, so it's not something new. And that basically something happened after they purchased the truck. But again, their deal, we just provide the funds, or Omni provides the funds. They don't have anything to do with the actual dealings between the dealership and Wilson's. So they did sign it under, the Michigan court rule I cited, that they didn't deny and file an affidavit that it wasn't their handwriting. So pursuant to that, it should be under the court rules, prima facie evidence that they did sign the documents, and we did everything, or Omni did everything they could to lessen to lower the damages for them. They tried to explain to them that once they purchased it, that they were responsible, but I don't know what happened with the vehicle. It's unfortunate, but our contention is they didn't follow the Michigan court rules and as far as their responses, so everything should be an admission, and they also didn't deny the handwriting on that loan document. So we would ask that the court enter a judgment in our favor.
All right, Mr. Wilson, what's your response?
Sir, it's a lot more complicated and involved than that. This is the third truck that we attempted to purchase through Omni. Their vetting process, sir, is obscene. I've looked to buy a truck in Florida. I looked to buy a truck in North Carolina. I looked to buy a truck in Michigan, and then finally in Indiana. Now, each one of those loans, we went to go pick up the truck was subpar. It was check engine lights not running right. Every single time this has happened, Omni's worked with us through their offices here, local. Chelsea's actually went to high school with a couple of people that work here. They know each other well. The day that we went to go get this third or fourth truck from a different loan, it comes back. It's just got every problem under the book. We tried to work with the dealership on it. We told Omni day one, like, do not let them cash that check, because the dealership kind of Rochambeaued us outside in the parking lot at closing, and they kept the check inside after, we looked at the truck, gave it the final once over, and I'm like, this isn't going to work. This truck isn't running. And it's a $40-some thousand truck. We got on the phone with Caleb. We had a verbal back and forth. Hey, this has happened again. Like this, once again, you're telling us it's 110% through your vetting process, but this truck is clearly not what it is that they're selling is not a good product, right? So Caleb says, okay, good deal. Work with them on it, see what you can do. I'll take care of things from my end in the meantime. I said, all right, cool. I tried to work with him on it as far as like, if they can get it fixed and they can get things going, then I'll sign the title work and we'll move forward on the purchase. They did not do that, nor could they, because the truck was in such disrepair that, you know, they were just trying to off a truck that was garbage essentially onto somebody. Now, if you look at the work, they sold it back to themselves. They sold it back to themselves for $25,000 after they threatened to impound it from us and all this other stuff. I said, it's not my truck. I never signed the purchase agreement, the title work. I didn't sign that. And the reason I didn't was because we didn't want to purchase the truck. Omni was 100%, you know, this was made known to them day one. And then we worked with them on it for a couple of weeks. They kept stonewalling us as far as what was going on with the money.
Judge Middleton lost power. He lost power for a second, got himself kicked out. His system somehow reconnected quick enough where no one got booted out, but that's what happened. Yeah. Anyways, but yeah, this guy definitely is fighting the wrong party here. That he made it clear the first thing he said. Yeah, you got the loan. He just said, I told the dealership not to cash it. They cashed it. Okay, well, you got the loan. They cashed the check. You're fighting the wrong party here, my friend.
And the eventuality of it was that they sat with their own truck down there for a pretty extended period of time, to the point that Omni, going back and forth with them, basically told us, well, it's going to go up to auction. And I said, well, how are they going to auction their own truck to someone else? That doesn't make sense to me, because they own it. And then they auctioned it to themselves at Royal RV for half of what they were going to make us pay for it. Mind you, this is a truck that's got rust in the headrests from Houston. I come to find out it's a service truck from Houston, Texas. They lied on the Carfax. It's just, none of this was on the level, but Omni's trying to act like, you know, because a year has passed since the beginning of this, that they didn't do anything unscrupulous. And again, this is the fourth vehicle that we've went to purchase through Omni that we went to pick up. And one of them was a brand new 2024 Dodge Ram out of North Carolina that had and a diesel that had the entire catalytic converter set just ruined in it. Now, luckily, Dodge worked with the situation good. And because, I mean, I did buy that truck, straight up purchased it. And then the cats were bad. So then they took it back. They refunded the money. We have a history of this, because I'm not a guy who's going to go out and spend 50 grand on a truck or get myself locked into payments for something that isn't going to work. These vehicles, we use them for my business, which isn't doing great right now as it is. But this entire situation has really kind of put me on my butt this last year, not having a second vehicle, all but being like harassed every time I go into Omni to try to make this truck payment. It's a big embarrassing show in front of people in our small town. They've all but debanked me. They won't cash my checks. They won't, and they've acted like I've done something wrong. When this thing was talked about from day one, when that check went through, I said, hey, this is no good. This deal isn't going to work. I told them this is a flood truck. We went back and forth with the dealership on it, tried to work with them like Omni said. In the end, it was an untenable situation, and it just wasn't going to work out because A, they wouldn't fix the truck, and B, the value of the truck wasn't what they were trying to sell it for. The third time we drove it, we never had this truck at our house for more than an hour or two at a time, mind you. We did have it one weekend because we couldn't return it the very first weekend we got it.
All right, man. I love people that just contradict themselves in court on the very next sentence. We never had this truck for more than an hour or two, except the one weekend we did. We did have it for a weekend. Guy, yeah. Again, this case is very clear that you're you're in court. You're arguing the debt. The bank is suing you because you owe them this money. Has nothing to do with the bank. Why the truck sucks. You're going after the wrong person. Another Squid, thank you so much for the 5 gifted memberships. I appreciate it. Good to see you tonight, and thank you for the 5 gifted memberships. Welcome to the 5 new members. Thank you so much. Another Squid.
We were like, hey, this isn't going to work. And they're like, all right, well, you got to bring it back. I'm like, all right, well, when? And then it was like a Monday thing. It's the only time we even ever had the truck. This was like an extended test drive. So by the time they got it back, it was, well, we're going to impound it if you don't want to come and get it. And then they sold themselves for $25,000. That's where we're at with it, Your Honor. I never made a single payment on the loan because I didn't want the loan. I made that abundantly clear. And this.
Well, he would be convincing if he was suing the dealership for something. I'm not saying he has a case, but I mean, it's worth a listen for what he's saying. Yeah, absolutely. Sue the dealership. You told him not to cash the check, that you felt pressured into buying a truck after, when they were closing, and you told them not to cash the check. You were going to test drive it. Then you couldn't return it till the next day. When you returned, they cashed the check, and all of a sudden you own a truck. Yeah, no, you have a case against them, just not the bank.
This is where we're at with the thing a year later or whatever. And now the vehicle itself, I would love for someone to check it out, because it is absolutely 100% a flood truck from Houston, Texas. And they've got multiple trucks just like this down there on their lot. And then we've got Omni telling us that it's 100% great truck, meets the standard.
Let me stop. You haven't stopped to take a breath. You've been talking nonstop for about 17 minutes. The power went out while you were talking. I think the record was still on. I've got everybody back now. Let me ask you a question. Where's Omni's $50,000?
It's with the dealership that they were supposed to recoup it from. We went back and forth for a week and a half about this money and the fact that the check was not to be cashed in the first place. They
don't have an agreement with the dealership. They have an agreement with you. You got hooked up with some crooked sale, and you agreed with the bank to borrow $50,000.
No, sir. In reverse.
So, stop.
It was in reverse.
It's my turn to talk. You borrowed all this money, and Omni Credit Union paid it to these people you bought the truck from. So they've got $50,000 of Omni Credit Union's money. Then they repossessed this and sold it. And what Omni is suing you for is the difference. They're only the lender. This isn't an auto finance where you buy the car there. It's a bank. You went to the credit union, as you have in the past, and borrowed money to buy a vehicle. Will you stop interrupting me? I'll let you speak. I let you speak for a long time.
Yes, sir.
They didn't have anything to do with what kind of truck you bought or who you brought it from. You had a history of borrowing money from them, so they agreed to loan you this money. So you took their money and gave it to this person you got the truck from, which apparently was. All right, what happened?
They were given a check. They were told not to cash the check. They agreed not to cash the check until terms were sorted out with the truck.
Who's they?
The dealership and Omni as well, and the dealership.
Oh, no, you don't.
Everything was put on hold.
When you get a check, it's a negotiable instrument. You don't buy a truck and say, "Hey, don't cash this check." Once Omni gives you the check, they lose control of it.
No, they can decide whether or not to allow the dealership to cash it, and they had the opportunity to not let them cash it. We had the discussion. That was what was agreed.
How is that?
That's happened several times, sir. Several different times this has happened with vehicles with them, because they do a vettership. They have to vet the vehicle in order to make sure that their purchase is good, because that vehicle is now collateral for the monies. If the collateral doesn't stand against the monies that they've lended, then they won't lend the money. So they're not going to give me 50 grand for a vehicle that won't.
What's your authority for that? That's just the way you think it is?
No, sir. It's what we all agreed upon.
The law to say they have the authority to do this, or this?
Yeah, that's what happens when you buy a house. So that the house will send inspectors before they give you a loan for it or a mortgage for it. Yeah, I've never heard of a car lending company doing that. I'm not saying that it doesn't happen. That just kind of blows my mind. It sounds like he's talking about a mortgage.
It's just the way you believe it is.
We all agreed upon that, and I've seen that happen before with the situation. So I haven't not been in a situation like this with them before. And the way that they acted before was on the level, honestly, with scruples. This time they did not.
They who?
Caleb at Omni, and also Christine at Omni, or who I was dealing with.
All right, you're putting all this on Omni. Omni didn't have anything to. You selected this truck, found it, asked to borrow this large amount of money to apply to this truck. Now you at one point allege you didn't sign it, but you clearly
did. Never sign any title work. No, I didn't. I never signed any title work. They never repossessed the vehicle because it was always in their name. It was always in Royal RV's name. I never owned the vehicle, Your Honor. I never signed title work to the state of Michigan. I did not purchase the vehicle.
I don't know about the vehicle. You signed a loan to buy the vehicle.
Right, and it's a collateral loan.
Yes. All right.
Right, and so without sufficient collateral, the monies can't be allocated toward the debt.
All right, according to what? According to who?
According to fiduciary laws and the FDC, like that's how that works. If you get a vehicle loan,
authority for that?
I could, not on the phone, not in front of me, but I could certainly look it up for you. If the bank, so, and here's the other problem is the loan for the truck itself is actually over its end, just like the truck that I'm sitting in now. They've given me more money toward a truck that wasn't worth the value of the.
Yeah, Dan, he is so confidently incorrect. Something like this did actually happen to me when I was, I don't know, 19, 20. I tried to get a cell phone. And I don't remember how old I was. I was over 18. I think I was less than 21 though. I tried to get a cell phone. For whatever reason, the company that I went with maybe signed the contract before they, did a credit check and did all this stuff. Turns out, the deal they had on the wall, it was like, I don't know, $100 you would get a phone, whatever. And they were trying to charge me like $350 to walk out the door. I'm like, it says $100. I've got $200. I can't pay that. And they're like, okay, well, go get it and come back. I'm like, well, no, I can't pay it. I thought I was going to get it for $100, and that's what the sign says is what I came in here for. So no, I don't want this. And I walked out, and I got a bill a month later for service plan that I didn't have because they made me sign the contract before they went through all the other steps, and I had to fight that tooth and nail to get that off my credit. Yeah, you signed something, you got to check. It sucks, but that's what happens. You don't have the product, but. Yeah, that's how that works. So unfortunately, not saying it's right. I feel bad for the guy. He doesn't have a truck, and he's gonna be on the hook for $20,000. So yeah, no, it sucks. I learned that lesson at 20. He is a lot older than 20.
Truck. This is something that Dana Nessel is dealing with right now on a state level, and Omni has done this to me 3 different times where I didn't know until after the fact. But after the fact, I find out that they're giving loan amounts of money out for vehicles that aren't even worth the amount of money that they're loaning for them.
Well, none of this is your fault. You find some fly-by-night somebody to buy this 2019 F-20 Super Duty. You don't do your due diligence. You asked to borrow $41,000. And
sir, I did. I did my due diligence.
Stop.
Yes,
you've got no responsibility in this. None of this is your fault. You went to Omni and asked to borrow $41,000.
Yes, sir.
They gave you a check for $41,000, and that money was given to this seller of this truck. So they're out $41,000 less what they sold the truck for after it was repossessed. So, Ms. Escamilla, what's your position regarding this?
My position is, again, Omni is not in the business of vetting vehicles. When someone comes and asks for a loan, they're in the business of making loans, and they had a history with the borrowers. We did submit exhibits to the court as well as to the defendants that show that there is a title in their name, that shows they signed a purchase agreement, that show that they provided a insurance.
There's no title in our name. It's a lie.
And so they took out insurance so that they could drive the vehicle off the lot. So I dispute that they're saying that they never purchased the vehicle. I think it's unfortunate what happened to them, but the dispute really should be with the dealership. We also attached the documents that show that there was the repo cast. Omni, the reason it was sold back to the dealer is that Omni determined that was they could get the most money for the defendants to mitigate the damages rather than sell it at the auction. I think that the auctioneer RepoCast, who does this frequently, knew the values. But again, I feel for the defendants. This is unfortunate, but this is really a dispute with the dealership. Omni didn't sell them the car. Omni gave them the money, and they've been damaged and lost money from this.
Okay.
Yeah, that was your response. Okay. Everything she just said made sense. And again, what he is saying, as a logical person that may not understand the law or how contracts work, I get his side of it. I understand it. But he's not admitting that he messed up at some point. He signed a document he's saying he didn't sign. That's obviously not true. If you didn't sign it, you wouldn't have a title in your name. And even though you say you don't, you do. It's been submitted as a exhibit in this. You messed up somewhere, man. You shouldn't have given him the check. Maybe that's where you messed up. You should have held on to that check until you agreed on the car or the truck. You messed up. Like, he's just not taking any fault in this.
Looking for the title. Yeah, there are two $25,000 checks.
Your Honor, the truck was never. Your Honor, the truck was never titled in our name. That's a fallacy, and it was never repossessed. Repossession is a legal term, and it was never repossessed from us.
Oh, hush, Kevin. I need to talk to Naomi for a second. We let you talk long enough. I want to say hi to Naomi. Hi, Naomi. Don't worry. I appreciate you hanging out. You don't have to say you have zero extra cash. I understand that, being a single mom is difficult. Do your thing, work your butt off, raise those kids. I appreciate you for hanging out and leaving a little comment for me. So thank you so much. And report every outage. I have today, because I keep going to the website and but when I go to the website, this AI thing pops up, and so I type in, like, I have to log in. Like, it's dumb the way that that Spectrum has made their internet, their ISP. It's dumb, and every time I log in, report it, and they're like, "Oh, there's an outage. Don't worry. We're working on it. We don't know when it's going to come back, and if you call, we can't help you." That's essentially what it says every single time. It's dumb, and I'm not going to get compensated for it. I won't. My internet is owned by the apartment complex I live in, so I can't even call Spectrum directly. I got to call the commercial Spectrum, which sucks even more than regular Spectrum. So yay for me. But hopefully I'm moving soon. But Naomi, good to see you.
Because it was never in our name.
Yeah, here's a copy of the title. Vehicle number, ID number, 2019 Ford F-250, titled in the name of Chelsea Nicole Lafferty and Kevin Carl Wilson.
No, sir, I never signed that title. They printed that. That was something they printed. That's nothing we signed. We did not register it in the state of Michigan. We did not purchase the vehicle. And this was all made abundantly clear within the first 3 days of this going on.
Yeah, you purchased insurance on this vehicle, and
we just figured out a new layer to this. I missed that the first time I heard that. Her name is on the title as well. He is messing up her credit. Oh no, he messed up. He doesn't want to admit it. He is fighting that hard right next to her because he doesn't want to. He doesn't want to admit that he messed up. Dang. Uncle Dan, thank you so much. Super chat for naming. Oh, that's awesome. That is very sweet, Dan. Thank you so much. Thank you. And Germager too for Naomi. Let's go, Naomi. See, you got fans here, Naomi. Let's go. You guys are awesome. Thank you so much. Thank you.
So you have to
We
own
keep-
it to buy insurance on it.
No, sir, you
Yeah.
don't. You don't at all. We were told that we had to get insurance in order to test drive the vehicle. We did that. We held an insurance policy with State Farm at the time. That's all there is to it. If it was my vehicle when it took me off the road, I would have filed a claim. I didn't do that because I was told by my insurance company that was not necessary because we didn't own the vehicle.
That's hearsay.
Okay, I have proof of that. We can talk to the insurance company, but at the end of the day, my name is not on that title, nor would it ever be because it's a flood truck. I never titled that truck, therefore I never owned it. It was never repossessed because it was never in my possession.
All right, this is a super generous gifted membership. So Instant Pause Legal Fiction, thank you so much, my friend. I do appreciate it. That is super generous of you. 20 gifted memberships. Welcome to the 20 new members. Legal Fiction, you are awesome. Members Monday tomorrow night. Let's go. Thank you, Legal Fiction.
All right. Ms. Escamilla, what's your take regarding the title?
Well, I mean, there's clearly a title that's been filed with the Secretary of State. Our clients don't
No, there
file
hasn't.
titles.
No, there has not. There has not. That is a straight up lie.
Mr. Wilson,
Yes,
you're
sir.
very disrespectful. This is a
I
court
apologize.
proceeding. We're not sitting around the kitchen table. She's an attorney. You're not. If there was an attorney here, they wouldn't do what you're doing. And they wouldn't let you do it either. They wouldn't let you blurt things out and call people liars. There is a title in this matter where the vehicle is titled to you. There's proof that the vehicle was insured to you. And there's proof that you and your wife signed a loan agreement to purchase this vehicle. They are the people that lent you the money to buy the vehicle. They don't go out and inspect your vehicle to make sure it's worth that. If it isn't,
Yes, sir, they
that's on
do.
you. Then it gets
No, sir.
repossessed and sold. They sold it back to the company because they made more money doing that than they would by selling it at auction. You'd be shocked
sir.
at how low. I'm going to mute your microphone, Mr. Wilson. You don't have the respect to not speak when I'm speaking.
Yeah, it's not your show, Mr. Wilson. It's Judge Middleton's show and mine. And mine. I can pause it whenever I want to. Paracord, thank you so much for the 19 months. I do appreciate it. Good to see you tonight. Hopefully you're well. And I just hold on. Tammy, thank you so much for the PayPal. I do appreciate the PayPal. Thank you so much, Tammy. And lurk away. Lurk away. I do appreciate it. I wanted to make sure to shout you out. All right. Let's go.
And I'm going to tell you that you owe They sent you all of this documentation. They sent you the loan agreement. They sent you the notice that the vehicle was going to be repossessed and sold. They sent you a copy of the title to this vehicle. And they sent you the motion for summary disposition and explained what it was. You owe $19,474.44 plus cost, which is $160 in filing fee, service fee in the amount of $720, a motion fee in the amount of $200, and a statutory attorney fee of $75. The total is $19,806.64. You did electronically sign this loan agreement. They wouldn't have given you two $25,000 checks if you hadn't actually signed the agreement. They're the lender. if the vehicle was junky or dysfunctional or flood damaged, you have a cause of action against the people you bought the truck from, but not against the people that lent you money to buy the truck. Ms. Escamilla, I thought I had an order in here, but I can't seem to put my finger on it.
We did submit an order, but I can resend it to, the
Well, if you
email.
did, I've got it. Let me find it. Mr. Wilson, I don't have to like this, and you've got some impressions about how things are supposed to work.
Oh, he does have impressions on how things are supposed to work. Can you imagine? You get a mortgage for a house. A bank gives you, let's just make it easy, $100,000 for a house. And you move into the house and you find out that it was, a meth lab before you moved in. And then you sue the bank instead of the person before you that sold you the house, or, anyone else that covered that up. Can you imagine how dumb this is? Yeah. There is a little bit of due diligence that's a little extra on a mortgage that I explained earlier, but you're angry with the wrong person here. Way angry with the wrong person. And I feel bad for him. I do. I believe him that he never got this truck, or he had it for a day and didn't want to buy it. He had really quick buyer's remorse. He didn't do his due diligence before he drove it off the lot, but I think he drove it off the lot. Yeah, it's not the bank's fault.
But they're not correct. You cite authority as though it is authority. She cites the authority, which is actually the authority in her brief. Plus, you didn't respond to the brief. You just wrote me a letter that says, I didn't buy this truck. When clearly you did. You can appeal this, but right now you're paying for a dead horse, a truck you no longer have.
I appreciate you watching all my videos. I saw your next comment. Yeah, no, I didn't play this on Friday. A lot of channels did, so you probably saw it on another one. At least I don't think I played it on Friday. I don't think I was. No, Friday night was. I did have a small claims video, but it was all from Thurston County. I didn't play this one, but now I'm second guessing myself. I think other people would have said it. Okay, well, Cecilia, thank you so much for watching my videos. All right, we're just gonna play the rest of it. We're almost done.
You may have a cause of action, as I said, against the company that lent you the money. The court cost and the damages are $19,806.64. They're in the business of doing this. They didn't just wake up one day and decide they were going to do this. She did a very accurate job, just a minute, of providing the brief, the legal authority, the evidence that supports their claim, and you have a two-line answer that says, I didn't buy this truck. So go ahead and unmute your microphone and I'll let you get a final word in here. You can unmute it at your end. Let me try. Whoops.
Appeal it, and I'll hire an attorney, and we'll see you back here when we come back here. That's the only thing I have to say.
All right, thank you. You're good to go.
Can you show me that title with my name on it that I signed?
She sent it to you.
No, she
It's in
didn't,
the
because it doesn't
pleadings.
exist. If that happened, then they forged my signature, because I never signed that title. It never got taken to the state of Michigan. I did not sign that paperwork, and neither did Chelsea. And we have emails to confirm back and forth with
All right,
Omni,
well, thank
because
you. You can
they-
bring that up
they
on
tried
your
to-
appeal.
Why do I love it? I get so much joy when judges hang up on people. The fact that they have that ability just makes Zoom court so much more fun. You don't see it that often. Who is it? It's Magistrate Chisholm that loves the hang up button. He loves it. Like, all right, click. To be hung up on by a judge has to be, that last little salt in the wound. Again, I understand what this guy's argument is, and I do have some sympathy for him, but he's arguing he's arguing the wrong things to the wrong people. He could have just came in and said, you know what, I'm going to accept this, and then I'm going to sue the crap out of the dealership. That's all he had to do. He could have made this easy, but he's fighting the bank. He already accepted the money. Can't help you there. Can't help you there. All right. Real quick. Julie Ann, good to see you tonight. Thank you so much for the super sticker. I do appreciate it. And we got a new member. 648 Crescent. Crescent. Okay, Crescent. Thank you so much for becoming a new member. Welcome to the family. I do appreciate it. Welcome. Members Monday tomorrow night. Come hang out with us. All right. We got probably about a minute left of this, so I'm going to let the rest of it play out, and I'm going to go attempt to find someone to raid. Thank you guys so much for hanging out with me tonight. Tonight has been amazing. You guys are awesome. Thank you so much for the super chat, the gifted memberships, the membership milestones, and also, as always, the mods. Thank you so much for your hard work. You are the backbone of the channel. I don't thank you enough, so thank you so much. And yeah, that's it. Let's see. Tomorrow night's Members Monday. Next week is normal. It's the week after that's going to start getting weird because that's my birthday week. So it's going to start getting a little weird. We'll talk about that throughout next week, though. Because Heather's coming to visit. Yeah, the schedule's going to be a little off. But yeah, that's not next week. That's the following week. So you guys are awesome. Let me go find someone to raid. And yeah, I'll pause it right at the end and let you know who we're raiding. So let's just finish this one up.
You could go to the Secretary of State and see I don't know where the title is now. I don't know if I got sent back, but he has the same copy of the title that was filed as an exhibit. Obviously, I wouldn't be very happy either, paying $19,000 for a truck that I no longer have. And maybe this was a bad deal all the way around, but it wasn't Omni Credit Union's bad deal, it was his. So according to him, you guys should just eat the $19,000. At any rate, Ms. Escamilla, I didn't give you a chance to say very much, but you pled this matter well. The pleadings speak for themselves. You've got all the exhibits, affidavits, documentation, the loan agreement. He can appeal the motion and hire a lawyer and see if he can get any traction, but I think my ruling here is accurate. All right. That was not much fun, but my ruling stands. And we'll send a copy of that, and then they can decide what they want to do. But this is a very unpleasant collection case, I suspect.
Thank you, Your Honor.
All right. Yeah, now that's actually it. The video's over. Lone Wolf is surprisingly live right now, so I have it set up to rate him. He's the only one I saw. And yeah, I did see who said it? Whoever said Legal Fiction, that KCC's live. I was looking, and I didn't want to make the same mistake I made with John Lindy the other day, where I started like, oh, they may have blocked me, and I had no idea what I was talking about. Turns out it was members only. So I did check, and you were right, it's members only. So KCC, if anyone's a member at KCC, she's live right now. I have a set up to raid Lone Wolf. That is the only person I have live on so I can't even suggest anyone else. So go jump and say hello to Lone Wolf, and I will see you guys tomorrow night for Members Monday or Tuesday night. Tuesday night we'll be at 7. We'll be at 7 because it's yoga night for Heather. So yeah, that's it. That's all I got. Till I say bye. You guys are awesome. Ha 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 ha. I knew that was coming. I knew it was coming. Thank you, Legal Fiction, for all your support tonight. I appreciate you, man. And yeah, I knew that was coming. You didn't get me this time. Fool me once, shame on me. Fool me twice. Well, you're not gonna fool me again. Okay, bye.